Before I leave to the speakers and author of the book to discuss at length on the...
My name is Sangeet. I had the honor of being a member of the Anwar Ibrahim defense team during the Sodomy II trial and appeals. At the stage of the High Court and the Court of Appeal, my role was to assist the late Mr. Karpal Singh, lead counsel at the time. At the federal court, I addressed certain legal issues before the bench of the federal court with the invaluable guidance of the then lead counsel, Datuk Seri Sri Ram. I am also the daughter of the late Karpal Singh. Ladies and gentlemen, we often hear terms such as the rule of law, the right to a fair trial, fundamental freedoms, human rights, equality before the law. Our federal constitution provides guarantees of these wonderful notions, subject, no doubt, to the limits of the law. But really, what does it all mean? The rule of law is the supremacy of the law, which means that it is the law that should prevail over every citizen, irrespective of rank. It means that the Prime Minister of this country is equally subject to the law, just as any other citizen. It must mean that the government of this country is equally subject to the law, just as any other citizen. That is paramount in countries where dictators and kleptocrats rule. While it all sounds good on paper, there is in reality only one thing that can guarantee the rule of law. That is an independent and impartial judiciary. A judiciary that will not subscribe to the philosophy of the ruling party. A judiciary that will boldly rule in favor of the law instead of succumbing to invisible pressures of the executive. Only an independent, fearless judiciary can protect the minority from the majority. Only an independent, fearless judiciary can protect the rights of the ordinary citizen from unlawful acts of government. To me, that is the true test of a democracy. Today, I'd like to tell you a little bit about what happened behind the scenes while working on this defense team. It is public knowledge that Anwar Ibrahim and Karpal Singh crossed each other's paths initially as political rivals. But many of us witnessed that relationship grow into one of camaraderie, mutual respect, and a deep, genuine affection for each other. In fact, I'd say my father grew quite protective of Datuk Seri Anwar Ibrahim in many ways. At no point was he going to allow his serious medical condition stand in the way of defending his clients, most of all, Datuk Seri Anwar Ibrahim. Ladies and gentlemen, from the outset, it was really quite obvious that the charge against Anwar Ibrahim was a politically motivated one. It was widely reported, many of you may remember, a few days prior to the alleged incident, Najib Razak had met with the complainant. Initially, Najib Razak denied that. He said he did not know the complainant. Later, he admitted having met the complainant before and after the alleged incident. A coincidence? I think not. It was also widely reported that Shafi Abdullah, who later was to be appointed as the prosecutor to lead the appeal in the Court of Appeal, admitted having been at Najib Razak's residence at the same time the complainant happened to be there. Of course, he denied being part of the conversation between the complainant and the then PM. But wasn't this in itself highly suspicious? But at the end of it all, Shafi Abdullah was deemed to be the most suitable to prosecute. The trial then began at the High Court and spread over a span of 2 years. It was a mammoth trial involving numerous applications, including applications to recuse the trial judge. I will say quite confidently that from the beginning to the end, the defense was kept in the dark about matters that were directly relevant or beneficial to the defense case. Ultimately, Datuk Seri Anwar was acquitted at the end of the prosecution's case. However, in acquitting him, the trial judge made a rather curious finding, amongst others, that the court could not with 100% certainty exclude the possibility that the integrity of the samples had been compromised. Any criminal lawyer would tell you immediately that there was no such 100% sure rule. That obvious and possibly intentional error on the part of the law, on the part of the judge, amongst others, paved the way for the prosecution to launch its appeal. The way in which the appeal was conducted, ladies and gentlemen, was even more troubling. I remember quite clearly that the appeal was heard on 2 days, on the 6th and 7th of March, which was a Thursday and Friday. In the week before, we appeared at a case management to have all interlocutory matters set for hearing before the court, including pending interlocutory applications before the Court of Appeal and the Federal Court. Each one was fixed in the 3 days before the appeal was fixed. We were pushed into hearing all interlocutory appeals, including the main appeal, in the space of 5 days. The application to disqualify Shafi Abdullah's appointment was quite swiftly dismissed by the Court of Appeal on the Monday. Stay pending an appeal to the Federal Court was unsurprisingly denied. The next day, we found ourselves before the Federal Court to argue an appeal against the decision of the Court of Appeal dismissing the defense's application to call a witness to testify. Again, we were booted out of the Federal Court before midday. On Wednesday, again we appeared before the Federal Court to argue an appeal against a decision of the Court of Appeal dismissing the defense application to disqualify Shafi Abdullah. That one is particularly interesting. Ladies and gentlemen would remember that I had said that that appeal before the Court of Appeal was only heard 2 days prior on the Monday. The defense team filed the papers of the appeal to the Federal Court on the morning of Wednesday, late morning of Wednesday. We were told to be ready for hearing within an hour. Federal Court panel was pulled together. The prosecution was ready for battle, and within an hour we were arguing before a Federal Court bench. Less than an hour later, the appeal was dismissed. just in time for us to be before the Court of Appeal for the scheduled appeal on Thursday and Friday. It took 2 days, ladies and gentlemen, for the Court of Appeal to hear substantial arguments on very complicated issues of law and fact that took the span of 2 years to be heard at the High Court. The Court of Appeal understood it all in 1.5 days. We were rushed through most of the arguments. At the end of submissions on Friday, one would have thought the Court of Appeal might have taken some time to seriously consider the numerous records of appeal before it, the legal arguments made, but no. All that was required was an hour. The bench of the Court of Appeal retired for what I remember was maybe an hour, slightly more, and came back at about 5 p.m. that day with its verdict that Anwar Ibrahim was found guilty. That was at 5 p.m. Well, by that time, I think it was really quite obvious where it was all headed. Many of you would recall the Kajang by-elections. This was a Friday that we were before the Court of Appeal, and the nominations for the Kajang by-elections was on the Monday or Tuesday that followed. It could not be clearer that at all costs, Anwar Ibrahim had to be disqualified. At 5 p.m., Mr. Karpal asked the bench of the Court of Appeal for some time to get its submissions ready in relation to mitigation, because there were very serious medical conditions for the court to consider before deciding on sentence. Under normal situations, in normal situations, it's really quite natural for a court to have given us time, for us to have produced before it reasons to consider a reduced sentence. Medical records would have been crucial. Yet, the Court of Appeal told us, it is not necessary, we will take your word for it from the bar. Without a second thought, our request for time was denied. We were given a few minutes to prepare for mitigation. I remember quite clearly it was getting dark outside as evening set in. And we began submissions in relation to mitigation at close to 6 p.m., if not past it. At this point, I noticed my father was a little bit dehydrated. And he appeared a little bit unwell to me. I had noticed it earlier in the day, and I had kept asking him if he was all right. His words to me, yes, girl, stay focused. I remember Ram, my brother, also counsel on the defense team, was on his feet submitting when I felt my father's hand begin to tremor under the table, perhaps due to not having eaten much that day. And I whispered, we need to stop immediately. At that point, my father turned to me and said, it is very clear what is going on in this court. They will proceed in our absence, and I will not abandon him at this stage. He was right. Nothing would have stopped them from delivering the sentence that day. It must have been past 7 p.m. when the Court of Appeal delivered its sentence. Anwar Ibrahim was sentenced to 5 years imprisonment and officially disqualified from standing in the Kajang by-election. Never in my practice had I experienced such a thing. The manner in which the entire appeal was conducted, the panel sitting well into the evening, it was unheard of. And it was to my greatest disappointment that day to watch the judiciary so obviously play to the tune of the ruling party. What a disgrace it was. A few months later, we found ourselves before the federal court. Perhaps the federal court put on a better show. We were heard over the course of 1 week, and it appeared that our arguments were actually being heard. But at the end of it all, Datuk Seri Anwar Ibrahim went into prison at the hands of a puppet-like judiciary. I said at the beginning that to me, the true test of a democratic government is judicial independence. But in order for this to exist, judges must be free to exercise judicial powers without interference from government. I say with all due respect that under the shackles of the shameless BN government, judicial independence appeared to be at its lowest. Look at the way in which the Court of Appeal was hurried. Could it be more obvious that it was to accommodate hidden instructions in view of the impending Kajang by-elections nominations? I always found the composition of the bench interesting when it came to cases involving the government. I remember appearing together with Mr. Karpal in a matter presided by the then Court of Appeal Judge, Justice Apandi Ali. In a heated exchange, Mr. Karpal was prompted to bluntly put to Justice Apandi Ali, "You have the stamp of UMNO on your forehead." It is a well-known fact that Tan Sri Apandi Ali then went on to become the Attorney General. His past political affiliations and questionably successful tenure on the bench culminated in his publicly declaring, as reported, that his appointment as a member of the UMNO Supreme Council in July this year was like a fish returning home. Soon after that, he was reported to have declined the post. But the question that arises, ladies and gentlemen, the obvious question is the long-standing obvious political connection between him and the BN government. The role he played within the judiciary was instantly tainted. Not only did it appear that the judiciary was influenced to act in favor of the government, but also the compromised position of the then Attorney General was so glaringly obvious from the string of politically motivated prosecutions. The current administration really must set things right. Respecting the rule of law is far more than mere lip service. Having said that, ladies and gentlemen, I tell you this. We, the defense team, knew better than anyone else during the Anwar Ibrahim trial and appeals that we stood against the tide. But we turned up in court on every occasion with renewed hope that justice would be served. Till that very last day, there are many members of the judiciary who are indeed fearless, despite invisible pressures. And it is them who can hold their heads up high. It is them who give us reason to hope. This country will only really flourish when confidence is restored to that great institution, the judiciary. Mark, I've had the privilege of very quickly reading the book, and you've thoroughly examined the evidence and legal arguments made throughout the trial and the appeals. The book is not simply a baseless attack on the Malaysian criminal justice system. but instead presents a well-balanced view of what transpired. Thank you, Mark, for very carefully documenting this trial. It will certainly go down in history as an example of the gross failures in the Malaysian justice system. But more importantly, it documents the journey of a nation through this man who fought against all odds in the name of justice and freedom. Thank you.